Let's talk about something very important that is going to help you when executing contracts. When we're talking about contracts here, we're talking about agreements. For instance, tenancy agreement, partnership agreement, etc. And that is terms of a contract. Let's look at the types of terms that we have in a contract under our law. Welcome to my channel. This is Law Talks and Gist. If you're seeing my face for the first time, thank you for stopping by. Please like, share, comment, click on the subscribe button, and kindly turn on the notification bell so as to be notified each time I upload a new video. And if you're a returning subscriber, thank you so much for always stopping by. You know I love you. Thank you. Now let's dive into the video. So under our law, we have two types of terms of a contract. Number one, implied terms. Number two, express terms. When I'm talking about terms, I'm talking about like covenants. So now let me explain the two terms. First, let me explain what an express term is. Express terms are terms that are written in the contract. Terms that are written in the agreement before you sign. Those ones that you have seen already and you have agreed to. That once you sign, you have agreed that these terms will bind you. You have seen it already, you have read, and you have agreed before you now sign. Those are express terms because they are expressly stated in the contract agreement. While implied terms are provisions that the court assumes were intended to be included in the contract. Now, if there is any term that was not expressly stated in the contract before you sign, maybe after signing the contract, a particular party breaches and a matter comes up before the court, the first thing the court is going to ask will be, what was the provisions of the contract? What were the terms stated in the contract? And the court will now look at it. Now, if the issue that came up before the court is such that was not covered in the contract, no term covered it in the contract, the court may imply a term when necessary in order to enable the parties perform their contracts. So such a term that is assumed by the court is called an implied term. It was not expressly provided in the contract, but the court assumes that such was intended by the parties. So the court can also imply a term based on precedent. Maybe such a case had already come up before the court and a decision was reached. So the court may imply such a term in order to address the current issue. Now you understand that in every contract, there are express terms, those ones written on the paper before you sign, and implied terms, those ones that are not written but only assumed by the court when an issue arises from the contract. Maybe one of the parties breached. I hope this video helps you. Thank you so much for watching. See you in our next video.